Hey there, legal eagles. We're diving deep today into remedies before a judgment gets finalized. And a court ruling comes down. But the case isn't quite over just yet.
Yeah, exactly. Like, what safety nets and second chances do you have built into the legal system, those crucial maneuvers you can pull before a judgment's set in stone?
Okay, so cracking open our 2024 Golden Notes remedial law. We're focusing on two key areas. First off, Rule 37, those motions for a new trial or reconsideration, those like wait, hold on moments. And then it's Rules 40 through 45 and 64, covering appeals and other ways to take a case up the legal ladder.
Absolutely. And whether you're a legal prepping for your next case or just curious about how the law works, understanding these remedies is essential.
So let's start with Rule 37 and these so-called second chance motions. We've got the motion for a new trial, the MNT, and the motion for reconsideration, the MR now. Are these basically the same thing, just with different names?
Not quite. Think of them as two different tools in your legal toolbox. An MNT aims for a complete do-over, a brand new trial like the first one never happened.
So if you found some huge evidence after the trial wrapped up, like proof a witness lied or a document that changes everything, that's when you'd go for an MNT.
Exactly. It's like hitting the reset button. An MR, on the other hand, asks the court to look at its decision again based on the evidence already out there.
Okay, so no new evidence allowed in an MR. It's more about saying, hey, judge, you missed something, or I think you applied the law wrong.
You got it. Maybe the judge miscalculated damages, misinterpreted evidence, or used a legal precedent that doesn't actually fit the case. An MR could be your best bet then.
Now, our Golden Notes have specific requirements for both these motions. They got to be in writing, stating the reasons for filing, pretty straightforward. But what about extra evidence? Do you always have to bring more documents?
It depends. For an MNT, you often need to back up your claims. Affidavits, expert testimony, documents, anything to strengthen your case for a new trial with an MR, though you're focused on what's already there, highlighting the errors or misinterpretations.
Makes sense. Timing must be crucial here.
Yeah.
What are the deadlines for filing no room for procrastination in law?
You're right, deadlines are key, and the Golden Notes hit this hard. You file either motion within the period for appeal or are within 15 days of getting the judgment, no extension, so don't even think about pushing it.
Talk about pressure, and speaking of appeals, our source mentions a fresh period rule. Sounds important.
It is basically filing a motion for a new trial or reconsideration pauses the clock on your appeal deadline. After the motion's decided, you get a fresh 15 days to file that appeal.
So it's like a safety net, a second chance to rethink things after the court rules.
Exactly. Now, pop quiz time bar exam style. Imagine you're representing a client. Their motion for a new trial is denied. What's next?
Okay, listener, think carefully. This is where it gets tricky.
Don't overthink it. Appeal the judgment itself, not the denial of the motion. That's a common mistake. Remember, the denial isn't usually appealable on its own.
It's about the bigger picture.
Yeah.
The final judgment you're fighting now. One thing that caught my eye in the Golden Notes, newly discovered evidence. As grounds for a new trial, it doesn't literally mean it just appeared right.
Great observation. Newly discovered just means it's newly available to you. Maybe a document was misfiled. A witness comes forward, new info through investigation. Could you have gotten this evidence during the trial?
Like finding a treasure map to evidence that was always there, but you couldn't access it before.
Exactly. It's all about a fair chance to present that evidence. Okay, so we covered second chances at the trial level, but what if that's not enough? That's where appeals come in.
Perfect. Let's climb that legal ladder to explore appeals and other ways to review things in part 2. Okay, so we've looked at those second chances you get at the trial court. What happens when you've tried those options, but you still think the court got it wrong?
That's where appeals come in, seeking review from a higher court, hoping they'll overturn the lower court's ruling. And of course, there are specific rules for this whole process.
Right. Our trusty 2024 Golden Notes remedial law focuses on appeals from the RTC, the regional trial court. Can you break down the different types of appeals you can take from there?
Sure. The most common is the ordinary appeal under Rule 41. This is what you do when the RTC acted in its original jurisdiction, meaning it was the first court to hear the case. The typical trial, where you have evidence, witnesses, and a judge makes a decision.
So like a contract fight between businesses or a personal injury case of a car accident, those would likely start with an ordinary appeal if someone wants to challenge what the RTC decided.
Exactly. Now there's a petition for review under Rule 42. This is when you're challenging an RTC decision that was already an appeal from a lower court, like the municipal trial court.
So you're taking it up another step on the legal ladder. If a landlord-tenant dispute started in the MTC, went to the RTC, and someone's still not happy, A petition for review would be next.
Precisely. And finally, the big one, a petition for review on certiorari under Rule 45. This one's for pure questions of law, and it goes straight to the Supreme Court, skipping the Court of Appeals.
Wow, going straight to the top. That must be for some seriously big cases. What kind of situations would need that kind of appeal?
Think landmark constitutional cases, challenges to laws, or when a major legal precedent needs to be set, not your everyday appeal. That's for sure one key thing to remember about appeals, no matter the type place. You can't bring in new evidence or arguments that weren't presented at the trial court.
That's fair. You can't just surprise the other side with new stuff at the last minute. But what if the lower court made a clear mistake? Like they totally missed a key piece of evidence or got a legal concept wrong. Is there anything you can do once the judgment is final?
Well, that's where the doctrine of finality comes in. Once a judgment becomes final, it's generally set in stone. It gives closure and stops cases from dragging on forever.
So finality is important for efficiency in the legal system. But there must be some exceptions. What if a judgment is obviously wrong or unfair?
You're right, there are exceptions, like simple clerical errors, those can be fixed. Void judgments made without authority can be overturned, and sometimes even if a judgment is valid, new circumstances might pop up that make it unfair or impossible to enforce.
Give us an example when that might happen.
Our golden notes mention a property dispute where the judgment was based on a bad land survey. Years later, new evidence showed the survey was way off in that case. The court might reopen things to make sure the outcome is fair.
So even years later, a judgment could be reversed if there's strong new evidence or a major change in the situation. That's pretty interesting.
It shows how complex these remedies can be and why it's so important to understand the details. Remember those bar exam scenarios we talked about? Let's try another one this time about appeals. Imagine your client lost at the RTC and wants to appeal. You look at the case and there's no problem with how the law was used. The evidence supports the RTC's decision and there are no new legal arguments to make. What do you tell your client?
All right, listeners, think about this one. It tests your understanding of why we have appeals and what they can and can't do.
The best advice is don't appeal. Remember, appeals aren't about retrying the whole case. They're about looking for errors if there's nothing wrong. Appealing is a waste of time and money.
Good point. It's about picking your battles and knowing when to accept a decision, even if you don't like it. But what if your client is totally convinced they're right and wants to appeal no matter what you say then?
That's tricky as attorneys. We have to do what's best for our clients, but we also have a duty to the court. If a client wants a frivolous appeal, one with no legal basis, we might have to stop representing them.
So you have to balance what your client wants with your ethical duties as an officer of the court. Not always easy.
Exactly. Now let's switch gears to Rule 64, the special civil action for certiorari.
Okay, new legal adventure. What makes this special civil action different from the other remedies?
Well, unlike appeals, which focus on legal errors, a special civil action for certiorari challenges acts by a lower court that are done without authority or with such a big abuse of discretion that it's basically like they didn't have authority.
So it's like saying, hey, that lower court went too far. When would you use this?
Imagine a case where the lower court made a ruling on something totally outside its power, or their decision was so unreasonable as like they had no jurisdiction. That's when you might use a special civil action for certiorari.
So it's a way to keep lower courts in check and make sure they're not overstepping.
Exactly. It's a safeguard against abuse of power. Let's try a bar exam scenario that combines appeals and this special civil action. Imagine your client, a government agency, issued a cease and desist order against a business operating without permits. The business owner filed a motion to quash the order, saying the agency had no right to issue it. The motion was denied and the owner wants to appeal. What are their options and what would you recommend?
Ooh, this is a good one. Listeners, think about appeals and this special civil action as you work through this.
The owner has two choices. A regular appeal arguing the lower court was wrong to deny the motion to quash. But since it's about jurisdiction, a better path is a petition for certiorari under Rule 64, challenging the agency's authority to issue the order.
So you pick the remedy that directly tackles the main issue, which here, whether the agency had the power to do what it did.
Exactly, and this brings up a key concept, the doctrine of hierarchy of courts.
Okay, sounds important. What's that all about?
It means cases have to be filed in the right court based on their jurisdiction. We have a system with the Supreme Court at the top, then the Court of Appeals, then the trial courts.
Like a ladder, each rung is a different level of court authority.
Exactly. This ensures cases go to the court that can handle them, lower courts for less serious stuff, higher courts for complex issues and cases with bigger implications.
Makes sense. It keeps things organized and makes sure each court is working on cases it's supposed to.
Right now, back to remedies. Remember the special civil action for certiorari under Rule 64? There's a special rule for that.
Okay, tell me more.
The rule on exhaustion of administrative remedies before you can file that petition, you have to try all the options within the agency you're fighting.
So go through the agency's process before going to court.
Exactly. This gives agencies a chance to fix their own mistakes before the courts get involved.
It's logical to try and solve things at the source before escalating. But what if someone skips this and files for certiorari too early?
Their case will probably get thrown out. The courts won't hear it if they didn't try to fix it within the agency first.
So that's a crucial step you can't miss. It shows how important it is to know the rules for each remedy.
Absolutely. Navigating legal remedies is like a maze. You gotta know the rules to succeed.
Well said. We've covered a lot from appeals to special civil actions. These remedies are key for anyone dealing with the legal system. Man, we've really gone deep into these remedies before a judgment is final, haven't we? From those second chance motions at the trial court to all the ins and outs of appeals and those special civil actions. It's been a journey.
It has, and we've really just scratched the surface of this area of law.
I can imagine, but even just this little bit shows how important these remedies are for anyone dealing with the legal system, whether you're a lawyer or just someone facing a legal issue for the first time. Knowing what you can do and when to do it can really make a difference.
Absolutely, and that brings up a really important point. The right to appeal is a big part of our system, but it doesn't mean you can just keep fighting a case forever. There are specific rules, deadlines, and reasons for an appeal that you absolutely have to follow.
Right. Our 2024 Golden Notes remedial law really lay out all those rules and deadlines clearly. And trust me, listeners, missing those deadlines or filing the wrong motion can completely mess up your case.
For sure, it's like you're in a maze and one wrong step takes you back to the beginning, or even worse. That's why having a good lawyer is so important. They can guide you through everything. Make sure you do things right and make the best arguments for you.
Definitely don't try to do this stuff on your own, folks. But even if you're not in a legal battle right now, just learning about these remedies is so interesting. It makes you think about how the legal system tries to balance making sure things are fair with the idea that at some point a decision has to be final.
Exactly. There's this tension between those two goals. On the one hand, we need things to end, and for courts to be able to enforce judgments. Imagine if appeals could go on forever.
Right, be a total chaos. But on the other hand, what happens when a decision is wrong? What if someone loses their rights or is punished because of a mistake? That's where these remedies come in. They give you a chance to maybe fix things.
Exactly. And that brings me to a final question for you, listener. If the courts are supposed to make sure things are fair, how do these remedies balance that goal with the need for things to be final? It's something to think about as you keep exploring how the law works.
That's a great question. Something to really chew on. And for anyone who wants to learn even more, those 2024 Golden Notes remedial law are full of information. There's so much more to discover beyond what we talked about today.
Definitely. There's always more to learn in law. Who knows? Maybe we'll come back to this topic in a future deep dive.
Until then, keep those legal minds sharp. And remember, when it comes to legal remedies, knowing what you can do is powerful. The more you understand about your options, the better you'll be able to handle the legal system and fight for the right outcome. Thanks for joining us on this deep dive, and we'll see you next time.